It's all going down. Tyrone Bowman Live. Welcome to the conversation, everybody. Welcome to the program. We're going to get right down to the heart of the matter. I'm not going to waste any time with this video and the story that I'm going to be talking about. In an article written for the Wall Street Journal by C. Ryan Barber, written on yesterday, the headline reads, James Comey and Letitia James cases dismissed in blow to DOJ. Judge finds Lindsay Halligan, who led the prosecution of two of the president's perceived adversaries, wasn't properly appointed. So I'm going to give you an analysis and a breakdown from a legal perspective, along with some commentary as to why this case was dismissed. Welcome to the program. Good to see you, bad dude. And I also have a copy of the opinion and order granting the motion to dismiss the indictment against former FBI Director James Comey. So it's good to speak with facts, not based upon innuendos or hearsay, but dealing with facts. And I can tell you now that this case was dismissed based upon this, the Constitution. And I'll break it down to you. But let's get into the story. Let's start talking about it and find out where it's going to go from here. According to the article as reported in the Wall Street Journal, written by C. Ryan Barber, quote, a federal judge on Monday dismissed criminal charges against both former Federal Bureau of Investigation Director James Comey and New York Attorney General Letitia James, ruling that the prosecutor President Trump chose to bring the cases was unlawfully appointed. The pair of decisions from Judge Cameron McGowan Curry dealt a setback to the Justice Department in two high-profile cases. It brought after Trump publicly called on Attorney General Pam Bondi to prosecute several of his prominent critics, including Comey and James. Comey and James both contested Lindsay Halligan's appointment as the interim U.S. Attorney in Eastern Virginia, while also pointing to Trump's public statements to argue that his prosecution was rooted in the president's desire for retribution against a perceived adversary. Curry, a Bill Clinton appointee who normally sits in South Carolina, agreed with arguments from Comey and James that the administration had unlawfully bypassed the customary confirmation process by installing Halligan. Curry also rejected Bondi's ratification of the two indictments weeks after they were filed in a bid to bolster them against challenges to Halligan's appointment. So, ladies and gentlemen, what a lot of people don't understand is this. If you are going to get an indictment, convene a grand jury, have the grand jury agree that there are acts of criminality, not alleged acts, but real acts of criminality that have occurred, then you have to follow the letter of the law. Because if an individual doesn't follow the letter of the law, then constitutionally, a judge can rule on an entirely different matter: prosecutorial misconduct, ineffective assistance of counsel, abbreviation from the law. So I'm going to get further into this. Quote, the implications of a contrary conclusion are extraordinary, end quote, the judge wrote. Quote, it would mean the government could send any private citizen off the street, attorney or not, into the grand jury room to secure an indictment so long as the attorney general gives her approval after the fact. That cannot be the law, end quote. White House Press Secretary Carolyn Leavitt said that the Justice Department planned to appeal. Quote, this judge took an unprecedented action to throw these cases out to shield James Comey and Letitia James from accountability based on a technical ruling, and the administration disagrees with that technical ruling, end quote, Leavitt told Fox News. Halligan, she said, was both quote, extremely qualified, end quote, and lawfully appointed. All right, that's their assertion, but the judge ruled otherwise. I mean, they have the right to appeal. That's what they always do. They always appeal. But so does James Comey. He has a right to appeal as well. You see, just because somebody is charged with a crime, an alleged crime, that doesn't mean that they're guilty of the alleged crime that they were charged with. In this fast-paced, instamatic, viral flow, judging everything, everyone, everybody on camera in front of the whole world based upon assertions, innuendos, and non-factual, non-circumstantial things is what's wrong with the judicial system right now. Let me ask you a question. How many people right now, some of them you may know, some of them you may not know, are sitting in prison based upon a zealous prosecutor trying to get a quick conviction? Comey had asked Curry to dismiss the case, quote, with prejudice, end quote, a move that would have foreclosed reviving the prosecutions. The judge instead dismissed both Comey's and James's case without prejudice, leaving open a door for the Justice Department to potentially bring charges, a new legal expert says. And that's probably what they're going to do. They're going to bring them again and again and again. An attempt to do so in Comey's case could face complications, former prosecutors and other legal experts said, because the 5-year statute of limitations has now passed on the statement to Congress at issue. Trump had appointed Halligan, a former insurance lawyer and his personal attorney, with no prior prosecutorial experience after forcing out her predecessor. Well, you know, that is a plausible case on Comey's side. That a former insurance lawyer and former personal attorney for the president, and that she's now prosecuting the former FBI director. That's a plausibility factor right there for grounds for dismissal. E. Kirk Silbert, who had faced pressure to bring charges against the president's perceived foes. The president, Comey and James argued, gets a single 120-day period in which he can have someone serve as an interim U.S. attorney. And once that period expires, the judges in the district have the exclusive authority to decide who holds the position until the Senate confirms someone. In Virginia, Trump already burned through a 121-day window with his previous pick, Siebert, a well-regarded conservative prosecutor who remained in the role with the backing of the district judges until he left and was replaced by Halligan. The only thing that I take umbrage with is that all these Republican judges, people seem to think that no matter what type of decisions that they make, they're right. And if it's a democratically appointed judge, then they're wrong. That's what's wrong in the so-called judicial criminal justice system right now. Because people want to stack the deck with either all Republicans or all Democrats to rule in the favor of getting something done just to appease somebody. Now, what I'm going to do, I'm going to go straight to the opinion. And I'm going to read it here from my huge iPad. I'm turning it into a teleprompter. So let's go to the opinion in the United States District Court for the Eastern District of Virginia, Alexandria Division, United States of America versus James B. Comey Jr., defendant, criminal number 1:CR-00272-MSN. Order, opinion and order granting motion to dismiss indictment number 60, ECF number 60. On September 25th, 2025, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia, having been appointed interim U.S. attorney by the Attorney General just days before. Ms. Halligan secured a 2-count indictment charging former FBI Director James B. Comey Jr., with making false statements to Congress and obstructing a congressional proceeding. Mr. Comey now moves to dismiss the indictment on the grounds that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation of 28 USC subsection 546 and the Constitution's appointment clause. As explained below, I agree with Mr. Comey that the Attorney General's attempt to install Ms. Halligan as interim U.S. Attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, I will grant Mr. Comey's motion and dismiss the indictment without prejudice, meaning there's a possibility that they could bring the indictment again. I just lost my feed. Okay, I got it back. So what's going on here? The judge, in her judicial opinion, in her motion, she agreed with James Comey through his attorneys. Where's the smoking gun? Where's the egregious violation for the rule of law that took place? So here's some background and a legal background. The appointments clause prescribed the exclusive means of appointing officers of the United States. The text of the clause contemplates two types of officers: principal and inferior officers. And then they have a case citing C. Morrison versus Olson, 480 section US .654, 670.71, 1988. Principal officers must be appointed by the president, quote, with the advice and consent of the Senate, end quote. The Senate never confirmed Lindsay Halligan. She was never brought before the Senate. She was never brought before Congress. This is what this is alleging. She was never brought before a full vote of the Senate. And as a result, Comey, arguing to his lawyers, said that this was unconstitutional and illegal. How would you like it? Let's phrase it this way. How would you like it if the police came to your home without a warrant, kicked your door in with a battering ram? You're sitting there having dinner with your family. They violate your constitutional rights. They violate your person. They snatch you up, drag you out of the house, take you down to the police precinct at gunpoint, and try to get you confessed to alleged crimes. That's not true. Bad dude. That's not true at all. I know somebody who did call for the death of people, and I know somebody who has consistently lied about many things. So now Comey, through his attorneys, is fighting back. So if they decide to appeal the case, Comey will decide to continue on with it as well. All right, what was I saying here? Okay, here we go. Principal officers must be appointed by the president with the advice and consent of the Senate. The same process is also the default matter of appointment for inferior officers. So let's reverse it. If this was a democratically elected president and it was the same scenario, and a Democratic president did the same thing through his attorney general, do you think there would be a plausibility factor to indict? What do you think? It takes a different tone, doesn't it? Because in the eyes of MAGA, Republicans can do no wrong. You see how they're appalling silence, even as we're going through what we're going through in this nation. Now, by the way, I'm about to say something. This might be a side note, and I want to deviate from this topic for a second. I've been looking at a lot of these AI-generated videos on Instagram and other things talking about digital ID. People, stop being gaslighted. Billionaires have spent hundreds of millions of dollars to take over the internet with propaganda of fear, propaganda of what could be and might be, AI-generated videos, making it look like they are human speaking and they're nothing but robotic images being projected across the screen. And meanwhile, while they got you running around looking at the falsity of these videos and the other dumb videos talking about all the food is no good to eat, it's being manufactured, blah, 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 in companies, etc., etc., the fight for inflation has become appallingly silent. The fight to bring grocery prices down, the fight to bring gas prices down, the fight to save health care, Medicaid and Medicare, the fight about SNAP benefits. And this is what you all don't understand. In the big, beautiful bill, a huge provisionary exclusionary clause was written that there would be a massive overhaul when it comes to SNAP benefits. And so while they got you dangling that piece of cheese for you and you're running around constantly being concerned about the Epstein files and all this other silly stuff, they're stripping you of your constitutional rights. They're playing a political ping pong with your minds. Stay focused. James Comey, through his attorneys, they won. The case was dismissed with prejudice. And if they decide to appeal it, Comey and his lawyers, I'm quite sure they are preparing and gearing up for whatever comes down the road. Just think about how if it was you. Nobody had nothing to say when President Trump pardoned everybody who was involved in the January insurrection. Nobody had nothing to say about it. I'm talking about from the point of MAGA. Those dudes and dudettes aren't being tried again. They've been given a full pardon, a brand new lease on life. And yet ordinary people like you and I, who desperately need intervention to get some things done in our lives, we can't get it because we have no favor with politicians. So the same process is also the default matter of appointment for inferior officers. But the farmers, quote, recognize that requiring all officers, or the framers, quote, recognize that requiring all officers of the federal government to run the gauntlet of presidential nomination and Senate confirmation would prove administratively unworkable, end quote. They authorize an additional and streamlined method of appointment for inferior officers in the final provision of the appointment clause. Now, let's get down to the meat and substance of what the Constitution says and what it does not say. All right, this is a quote. It's talking about a United States attorney for each judicial district. Congress has also established a mechanism set forth for appointing interim U.S. attorneys when a vacancy arises. Section 546 essentially, quote, divides the responsibility for making interim appointments between the Attorney General and the district, end quote. Except as a provided in subsection, the Attorney General may appoint a United States attorney for the district in which the office of United States attorney is vacant. B, the Attorney General shall not appoint a United States attorney, a person to whose appointment by the President, so that office of the Senate, refused to give advice and consent. C, a person appointed as United States attorney under the exception may serve until the earlier of the qualification of a United States attorney for such district appointed by the President under subsection 54. So why is it that when you deal with the factual background, on January 20, 2025, Jessica Aber, who had been appointed by President Biden and confirmed by the Senate, resigned in her position as U.S. Attorney for the Eastern District of Virginia. The following day, the Attorney General appointed Eric Siebert as interim U.S. Attorney under whatever subsection of the law is. Mr. Ebert's 120-day interim appointment was set to expire on May 21, 2025. So on May 9, 2025, the judge of the district exercised their authority under Section 546 to appoint Mr. Siebert to continue in his role effective May 21. On September 19, Mr. Siebert informed colleagues of his resignation. According to news reports, Mr. Siebert had recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and New York Attorney General Letitia James. Mr. Siebert's resignation came hours after President Trump told reporters at the White House he wanted Mr. Siebert out, end quote. The next day, President Trump posted and later deleted the following message on social media. Pam, I have reviewed over 30 statements and posts saying that essentially, quote, same old story as last time, all talk, no action, nothing is being done. What about Comey, Adam Schiff, Letitia? They're all guilty as blank, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. A work rhino, in quotes, who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him. And there is a great case, and many lawyers and legal pundits say so. Lindsay Halligan is a really good lawyer and likes you a lot. We can't delay any indictment any longer. It's killing our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. 3 exclamation points. President. TJT. Okay, end quote. Now, less than 48 hours after Trump's post on September 22nd, 2025, the Attorney General issued an order authorizing Lindsay Halligan to be the interim United States Attorney for the Eastern District of Virginia during the vacancy in that office. So the procedural history is simple. On October 20, 2025, Mr. Comey moved to dismiss the indictment on the grounds that Ms. Halligan's appointment was unlawful under Section 546 and violated the appointment clause. Now I want to read this in the captions. Number 10, the grand jury was originally presented with a 3-count indictment. At some point, however, a second 2-count indictment was prepared. It is unclear by whom, which removed count 1 of the original indictment. Both indictments were signed by Ms. Halligan and the grand jury foreperson and were returned to the magistrate judge. During the indictment return proceeding, the foreperson explained that the grand jury did not agree on the very first count and that counts 2 and 3 were then put in a different package, which we agreed on. After speaking with Ms. Halligan, the magistrate judge accepted the return of the second 2-count indictment to reflect that it applied only to 1 count. So finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceedings, I ordered the government on October 28 to submit for in-camera review all documents relating to Ms. Halligan's participation before the grand jury. Quote, along with complete grand jury transcripts. Upon reviewing the transcripts provided by the government, I determined it did not include any remarks made by Ms. Halligan before and after the testimony of the sole witness. Accordingly, on November 4, I directed the government to submit a complete transcript and or recording of all statements made by Ms. Halligan to the grand jury on September 25, 2025. So, you see how this is being framed. Now, Mr. Comey filed his reply on November 10th. I heard oral arguments from the parties and took the matter under advisement. During the hearing, I raised concerns about the Attorney General's ability to review Ms. Halligan's presentation to the grand jury when, as of October 31, the government had not yet received the complete transcript of the proceeding. I also noted that based on my in-camera review, there appeared to be a gap in the grand jury transcript. Now, Judges have judicial discretion when it comes to matters of law. And based upon the judge's judicial discretion, this is what she concluded. And I'm going to get to the main part of this opinion. I'm not going to bother you with all the wherefore and hitherto's. So I'm switching down and I'm going to the conclusion of it. All right. Dismissal of the indictments is appropriate. The appointment clause, quote, is more than a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme, end quote. The clause not only serves as a, quote, a bulwark against one branch aggrandizing its power at the expense of another, end quote. Quote, preserves another aspect of the Constitution's structural integrity by preventing the diffusion of the appointment power, end quote. Quote, given its importance within our Constitution structure, remedies with bite should be applied to appointments that run afoul of the clause's restrictions, end quote. Here, Mr. Comey contends Ms. Halligan's unlawful appointment renders all her purported official actions void. He therefore argues the case must be dismissed because Ms. Halligan was not lawfully exercising his power when she appeared before the grand jury alone and obtained his indictment. And now in the judge's final ruling, it goes this way. Because they're over like 50 pages here. And I'm not going to read every page. All right, here it is. Dismissal will be without prejudice. Having found, this is the judge speaking, that Ms. Halligan's appointment violated 28 U.S.C. subsection 546 and the appointments clause, and that dismissal of Mr. Comey's indictment is warranted. The remaining issue is whether dismissal should be with or without prejudice, relying primarily on the Ninth Circuit's decision in United States versus Bundy. Mr. Comey urges me to exercise my supervisory powers and dismiss his indictment with prejudice. A with prejudice dismissal is necessary, he argues, to vindicate the interests protected by the appointment clause and to deter the government from using unlawful appointments to effectuate retaliation against perceived political opponents. Recognizing that a court may use its supervisory powers to implement a remedy for violation of recognized rights. And as a remedy designed to deter illegal conduct, the government, on the other hand, asserts that any dismissal should be without prejudice for Mr. Comey, comes nowhere close to showing flagrant misbehavior, substantial prejudice, or the unavailability of a lesser sanction. So ultimately, I believe the Supreme Court's appointment clause jurisprudence provides the answer to the with or without prejudice question in both Ryder and Lucia. The court essentially unwound the actions taken by the unconstitutionally appointed officer and restored the affected party to the position the party occupied before being subjected to those invalid acts. The conclusion for the judge says, the judge says that she will dismiss the indictment without prejudice, returning Mr. Comey to the status he occupied before being indicted. For the reasons set forth, it is hereby ordered and adjudged as follows. The appointment of Ms. Halligan as interim U.S. attorney violated 28 U.S.C. subsection 546 of the appointment clause of the U.S. Constitution. All actions following flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, were unlawful exercise of executive power and are hereby set aside. The Attorney General's attempt to ratify Ms. Halligan's actions were effectively and are hereby set aside. Mr. Comey's motion to dismiss the indictment is granted in accordance with this order. The indictment is dismissed without prejudice. The power to appoint an interim U.S. Attorney for the Eastern District of Virginia pursuant to 28 United States Constitution, subsection 546, during the current vacancy lies with the District Court until a U.S. Attorney is nominated by the President and confirmed by the Senate under 28 United States Code, subsection 541, and of course the affixed signatures of the Judge Cameron McGowan Curie, a senior United States District Judge. So here it is, ladies and gentlemen. Somebody says judges should not have that much power. Well, what about the Supreme Court judges then? What about the unchecked, unbalanced, unilateral power that the Supreme Court has? What about all the unjust decisions that the Supreme Court has rendered? Taking away people's constitutional rights, ruling cases that they know that they had no business ruling against. But it's okay, because the Supreme Court is pro-MAGA. You only have 3 dissenting individuals on the Supreme Court who don't necessarily go along with a lot of the decisions that the Supreme Court is making. When the first Supreme Court Associate Justice, the late Thurgood Marshall, was on the Supreme Court, you had a balance. You had an even balance when Thurgood Marshall was on the Supreme Court. Justice Clarence Thomas, on the other hand, you automatically know that he's not going to vote in anything in a favorable light when it comes to Black people. He's proven to be an obstructionist when it comes to Black folk. So the judge, in her judicial discretion, issued the order. The indictment was withdrawn. The case was dismissed. It's not a matter of term limits, because they're not going to have term limits. They tried it in the Senate. They tried it in the Congress. The appointments within the federal courts and the Supreme Court are for life, unless they egregiously and flagrantly violate the law, or they have some egregious, inappropriate things going on in their personal lives. So term limits, where's it coming from? That means you have to put term limits on everything, not just one thing. It can't be for something and then against something else. Just because a person does not like the decision doesn't mean that it's a wrong decision. Just like I've said many times on my program, a lot of people don't like the decision of this past presidential election, but that doesn't matter, because President Trump, who was then the presidential candidate, won re-election and was re-elected and became the now sitting president of the United States, whether folks like it or not. End of conversation. Whether you agree with him or not, it doesn't matter, because he's still the president of the United States. So people can't have it both ways. I do agree with term limits for everybody. No president should be able to run more than 2 terms. You've got too many old congressmen and congresswomen on both sides, in the Senate and in Congress, Republicans and Democrats. They need to retire. Seriously. They honestly need to retire. Let it go. Their prime is over. Half of them have dementia. They don't know what they're doing. They barely come to the meetings. They're out on sick leave half of the time. They're trying to adjudicate and trying to write legislation from their homes, and they're not home working, they're home recovering. Remember the late Justice Ruth Bader Ginsburg, when she knew that her health was completely failing, she made right decisions. So why do people want to tenaciously cling to power when absolute power leads to total corruption at some point in time. And if one set of people are going to be tried, then all people should be tried, not just one set. Well, we already know that I think Graham has more life in him than Mitch McConnell does. Mitch McConnell doesn't even know who he is. It's clearly evident they're hiding him. He doesn't even show up to the Senate anymore. Every now and then they parade him before the cameras, and they got about 4 or 5 people holding him up to the podium, making sure he doesn't continuously fall. He can barely read the teleprompter. He speaks barely above a whisper. It's time for him to go too. It really is. It's time for individuals to get to the point. You got to have some sensibility about things. And I'm going to close by saying this. What's more important at this point in time? The economy is important. Addressing inflation is important. Dealing with healthcare and Medicaid. Dealing with the agricultural industry. Dealing with the monetization by these billionaires who just want to control everything, everyone, and everybody. They want access to everybody's personal records. They want to know what you're thinking, when you're thinking, how you're thinking, where you're going, what are you doing, who are you doing it with. Intrusiveness all the way around, flagrant violation of the Privacy Act in this country. No one person or persons have the right, I don't care how many billions and billions and billions and billions of dollars you have, that doesn't give them the right to play Almighty God with people's lives. And if you sit back and do nothing about it, then you're just as guilty as those who are trying to usurp authority over everything, everyone, and everybody. And with Thanksgiving coming up, this coming Thursday, a lot of people are going to be homeless, hungry, and out on the streets. Thousands upon thousands will be evicted on Thanksgiving Day. The day after, many homes will be foreclosed on by unforgiving banks. Lending credit card corporations, they're going to be demanding that individuals' cards be canceled. Insurance rates are going up. Healthcare rates are going up. The price of food is still going up. The so-called thing about accountability, when you can control the Senate, the Congress, and the executive branch, it should be easy to get positive legislation passed. You know why it's not? Because they want people to agree with them so they don't seem like they are the obstructionists. And those who are against them, they want to try to marginalize them of being hate mongers and fear peddlers. Well, I looked at that network over there, the Racist and Bigoted Network, and they were highly upset yesterday. They couldn't believe that their case against Comey and Letitia James was dismissed. But they don't have any problem with cases being dismissed against certain people. Then the Constitution works fine. America's a beautiful place if it works in the favor of the rich and of the powerful. What about the poor, the disenfranchised, and the marginalized men and women within our society who don't have the millions and millions of dollars to stand up and fight for themselves, who don't have the best lawyers advocating for them, who don't have access to good Medicaid and Medicare, who cannot eat good, decent, clean food, and then you judge them and rail against them when they have to eat junk food and they have to subsist on what they can afford from the dollar store and the other stores. Well, if that's all they can afford, that's all they can afford. During the Depression era, they had potatoes and plenty of them. People forget about the Great Depression that hit America. They keep forgetting about the Irish potato shortage. They keep forgetting about the hard things that happen in this nation and in this country. because they're so caught up into their iPhones, and they're caught up in just making life easier for the rich and the powerful, and forget about the dismarginalized and those who are struggling and hurting every single day. So the indictment against Comey has been dismissed. And now I've worked hard all my life and I'm still poor. If you have a mind at Rick Young, you are not poor. Do like I do. Make your mind work for you. Think of a creative way to earn money. God gave each of us the capabilities to think, to reason, and to be creative with our thoughts. And nothing and nobody can keep you in poverty but you. I'm not an impoverished thinking, speaking, talking, acting man. I believe not only in the divine creator, I believe in what he put inside me. And so when the appeal takes place, I'm going to look for the appeal, and I'm going to read it on the program the same way that I read about the opinion and motion that was rendered concerning James Comey. All right, next up in the next video, I'm going to do an analysis and talk about the indictment against New York Attorney General Letitia James being dismissed. All right, ladies and gentlemen, I've got to run. Thank you for watching. Never surrender, never quit.